Senator Risa Hontiveros nataranta at agad na inamin ang kanyang kasalanan sa ginawa niyang kasinungalingan sa Senate session noong talakayan sa impeachment case ni Vice President Sara Duterte. Ito ay ukol sa naging desisyon ng Korte Suprema sa ibang mga kaso na umano'y may reverse ng desisyon ang ating hukom sa mga nagdaang taon. Risa, nagsorry dahil agad siyang sinupalpal ng Korte Suprema sa kasinungalingan niya. Pero bago ang lahat, mag-subscribe na sa aking YouTube channel upang updated ka sa mga mahahalagang balita sa ating bansa. Magugunitang, supalpal ang inabot ni Senator Risa Hontiveros mula sa Korte Suprema nang maglabas sila ng pahayag para pasinungalingan ang mga pahayag ni Risa Hontiveros na nagkiklaim na ang mataas na hukuman ay nagkaisang binaliktad ang orihinal na desisyon nito sa kaso ng League of Cities of the Philippines COMELEC. Agad namang humingi ng tawad si Risa Hontiveros at ito ang kanyang sinabi. Hontiveros admits mistake. Senator Risa Hontiveros admitted that she was wrong in saying that the League of Cities case was decided by the Supreme Court anonymously.
Yielding the floor to our Deputy Minority Leader.
Yes, what is the pleasure of the Honorable Hontiveros?
Thank you, Mr. President, and to the good gentleman from Pampanga. Gusto ko lang pong bigyan ng point of information, sagot dun sa tanong ng good gentleman mula sa Tarlac, that in fact, the Supreme Court has reversed a unanimous decision in a lot of instances before. Dalawa lang po ang ibibigay kong halimbawa. League of Cities of the Philippines versus COMELEC. Original decision, 2008. Reversal on motion for reconsideration, 2009. Isa pa pong halimbawa, International Service for the Acquisition of Agri-Biotech Applications Inc. o ISAA et al. Versus Greenpeace Southeast Asia. Original decision, unanimous, December 8, 2015. Reversed unanimously on MR din, July 26, 2016. So, hindi lang po tulad nung sinabi ni Minority Leader na there's always a first time, it has happened before. So, yung ganitong klaseng milagro na hinahanap, posibleng mangyari din po dito sa kasong pinag-uusapan natin. Malay po natin. Salamat po, Mr.
Noted.
President. Salamat
Mr.
sa good
President,
gentleman
may I know
from Tarlac.
from the
Nandun
good
into the
senator,
record. Senator Marcoleta.
may I know from the good senator if these decisions are bank decisions or divisions?
Yes, Mr. President, unbanked decisions po.
Well, you have to cite the
Gladly
jurisprudence.
cite the GR number po bang hinihingi, Mr. President?
Pagka sinabi po bank, lahat po ng members ng Supreme Court, 15 of them, unanimous.
To
Kasi po
reiterate what
baka division lang yan, 5 lang yun. Hindi po
No,
bank
Mr.
yun.
President, to reiterate what I already said, mga ano po ito, mga reversal ng unanimous Supreme Court decisions.
Yes, but I am
At sa
asking for
dalawang
qualification,
halimbawang
Mr. President,
ibinigay ko
whether
po
these are bank
on
decisions
MR.
or decisions by a division. And whether or not
Mr.
they were
President,
characterized by...
sinabi ko rin na po kanina,
Sandali
unbanked
po.
decisions po ito. Ay, hindi po.
Whether or
I
not
am
the
replying to
decisions
question.
are characterized by the following qualifications. 1, unconstitutional, void ab initio, violative of due process. All these are present in those jurisprudence cases as you cited.
Mr. President, bagamat para itong yung pinag-uusapan natin kaninang operative facts, kanina, simple lang yung tanong eh. May kaso na po ba na ang Supreme Court sa unanimous decision ay ni-reverse ang sarili nila? Ngayon, may dinadagdag na tanong. Pero sige po, yung League of Cities of the Philippines versus COMELEC, the Supreme Court, in its original decision in 2008, unanimously declared the cityhood laws unconstitutional. I will have to get more information po on the ISAA, reversal of unanimous decision. Pero malinaw na mga sagot na po ito dun sa original na tanong. So the original assertion na hindi po natin alam kung na-reverse na ng Supreme Court ang sarili nila sa original na unanimous decision has fallen by the wayside. Kasi the Supreme Court, as I said already earlier, has reversed a unanimous decision unbanked in a lot of instances before.
Dear Mr. President, dear colleagues, I believe this decision is of the highest public interest, whose consequences will echo through time and history. Maraming taon mula ngayon, pag-aaralan at hihimayin ito ng lahat. Mula sa mga estudyante, mga journalist, mga political analyst, mga academics, at higit sa lahat ng ating mga kababayan. One day, and this day will come, history will judge all of us based on our actions today, August 6, 2025. When history comes to remember, let's hope we stood where it mattered, that even in the face of doubt, we did what was right and just. With deep respect for the Supreme Court and all institutions of our country, Mr. President, I therefore second the motion to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Salamat po, Mr. President.
Mr. President, quick
Noted
reaction.
and entered into the records. Senator Marcoleta.
Mr. President, unang-una, yung sinabi ko pong speculative, sapagkat it was not based on my own speculation. It was based on my long practice as a litigation lawyer. Wala pa po akong nakitang isang unanimous decision. Ewan ko lamang po kung merong magbo-volunteer ngayon na abogado in the last 40 years na sinasabi ang isang unanimous decision na ang karakter niya ay sinabi na ab initio, void ab initio, unconstitutional, violative of due process. Maybe if we can speculate that all the members of the Supreme Court, after the filing of the motion for reconsideration, will resort to their worst, will resort to the worst angels of their nature. Maybe, baka ganun lang. What do we expect? We expect that 8 of them will reverse themselves altogether. Kung sakasakali naman po na in-archive natin, or whatever word is applicable, at sinabi, under miraculous circumstances, sinabi ng Supreme Court, we are all reversing ourselves. Eh di, continue natin. Anong problema? Pero kagaya po na sinasabi ko kanina, Mr. President, ang pagkakaluto nga po hilaw eh. Ipinipilit po ngayong ipakain sa Senado ang isang bagay na hilaw. Eh paano? Sinabi po ba ng Supreme Court na wag na kayong mag-impeach? Hindi po. Binigyan po tayo ng guidelines. Alam po ba ninyo kung bakit binigyan na ng guidelines ng Supreme Court kung paano mag-impeach? Kasi po, Mr. President, if you recall, the Supreme Court issued a notice on July 8, 2025, requiring at least 11 information from the House of Representatives and the Senate. The Senate made a manifestation na wala po kaming maibibigay sapagkat lahat po niyan ay makukuha ninyo sa House of Representatives. Alam po ba ninyo na 4 sa hinihingi ng Supreme Court ay nandun po sa puso ng due process? Ano po yung hinihingi? Sinabi lamang po ng Supreme Court, pwede bang ibigay nyo sa amin kung lahat ng miyembro ng House of Representatives ay binigyan ninyo ng kopya at kailan? Pwede bang ibigay nyo sa amin ang timing kung kailan nyo ibinigay at binigyan, kung paano nyo sila binigyan ng pagkakataong mabasa yung impeachment complaint? Pwede nyo bang ibigay sa amin kung every article of impeachment ay nakalagay doon ang mga dokumento na nagpapatibay ng artikulo? Pwede nyo bang ibigay sa amin kung nagkaroon sila ng pagkakataon talaga na mabasa yung impeachment complaint? Alam po ba ninyo kung anong sagot ng Solicitor General in behalf of the House of Representatives? Ito po yung sagot nila. It is the position of the House that these matters pertain to its internal proceedings, which have always been regarded as beyond the jurisdiction and scrutiny of this honorable court. Sa Tagalog po, wala po kayong pakialam dito sa amin. Yung inihingi po ninyo, kami lang po yun. Eh para tinatanong lang naman po eh. Binigyan nyo ba ng pagkakataon sila na mabasa? Bakit? Mahirap po ba sagutin yun? Ano pa po sinabi? This is especially because the matters referred to the preparation, circulation, and perusal of the impeachment complaint as well as its attachment are not governed by specific constitutional provision or the House rules. So dahil po wala sa Constitution at wala rin po sa House rules, ano po yun? Wardi-wardi na lang? So, ibig sabihin talaga, kaya po pala ang dami kong kasama doon, wala talaga silang kopya. Ako nga po hindi nabigyan eh. Bakit hindi po kinakailangan bigyan lahat? Baka sakaling, malay po ninyo, baka pumirma ako, hindi ba? Ito yung tinatanong po ng Korte Suprema. Kaya lang po siya nakapagbigay ng additional guideline. Sapagkat isip-isipin nyo, sasabihin sa Korte, wala nang pong masamang tinapay ang Korte. Pwede po malaman namin kung talaga nagkaroon ng pagkakatong mabasa man niya lang, ma-appreciate ang bawat dokumento na nakasalig dyan sa impeachment na yan. Para sa ganun, ay boboto siya sang-ayon sa kanyang sariling kagustuhan. Matibay ang gusto ng Korte Suprema. Gusto niyang makita na lahat ay dumaan sa kayusan. Eh hilaw nga po eh, Mr. President. Kanina ko pa po pinaiintindi, hilaw. Ba't hindi po kayo magluto ng mas masarap na kanin? Para sa ganun po, hindi tayo mahirapan. Maghintay na lang po kayo ng 6 months. Pwede naman eh. Ba't pinipilit po natin ng isang bagay na hilaw at pinipilit niyong ipakain sa atin? Mr. President. Sabi ko po kanina, Mr. President, I am ready to amend my motion. Kung kinakailangan po, that will be consistent on the respect accorded to the Supreme Court. Kaya lamang po, kailangan nating umaksyon. Sapagkat kagaya po ng nalalaman natin, naghihintay ang taong bayan na kailangan magkaroon po ng closure ito sapagkat kapag ito will be hanging on the balance, baka hindi po mabutihin ng ating mamamayan. Yun lang naman po ang pinakapunto rito, Mr. President.
Thank you, Senator Marcoleta.
President.
What is the pleasure of the minority floor leader?
Thank you, Mr. President. Caution is the word simply being put forth by this representation, Mr. President. Because again, sabi nga, wala pa raw siyang nakita. The distinguished gentleman from Tarlac, with due respect, said wala pa siya nakita na unanimous decision ng Supreme Court na baliktad. No? Again, I said, there's always a first time. Bakit ko sinasabi ito? I will quote the Supreme Court themselves. In the Pedro versus Romasan Development Corporation, GR 194751, July 1, 2015, I quote, Supreme Court nagsabi nito, while the Supreme Court's decisions are immediately executory, they are not considered final until the lapse of the prescribed period without a motion for reconsideration or upon denial of such motion. Sila nga mismo nagsasabi na hindi final eh. Ano ba naman ang masama na maghintay tayo na kung final na? For all you know, I might vote on the motion to dismiss. Hindi ba? If there is such a motion, because according to Senator Lacson, it does not exist in the Senate. It exists in the impeachment court. And what I'm being told is that it should be the defense, the lawyers of the defense who should pose that motion to dismiss, not a judge. I agree with Senator Lacson. There is no such thing as a motion to dismiss in the Senate. In the impeachment court, yes. Thank you, Mr. President.
Hindi po ba inamid na natin, Mr.
By the way, just one last point. Why did the Supreme Court ask Sara to comment? Kung final and executory na yan, bakit si Vice President Sara was asked to comment by the Supreme Court just a few days ago? Di ba? So, ibig sabihin, talagang pakikinggan pa nila. At baka sakali makita nila, dahil yung mga abogadong nakapaligid sa kanila, nagbigay sa kanila ng mga maling figures at maling impormasyon.
By way of
Mr.
point-
President, kaya nga po nag-i-speculate tayo rito eh. Hindi natin alam kung anong iniisip ng Supreme Court. Pero sa ngayon, sinabi po niya, immediately executory, at tayo lamang po talaga ang pinagsasabihan niya. At tungkol naman po sa motion to dismiss, na minodify ko na kung ayaw po ninyo, wala po akong magagawa. Pero may I invoke Section 135 of the Senate Rules. Ang sabi po rito, if there is no rule applicable to a specific case, the precedents of the Legislative Department of the Philippines shall be resorted to. So ang dami po nito eh. Dito po magkakaroon ng motion to dismiss dito. Lahat po ng precedents, kahit na wala po tayong specific rules, ay observe po natin ang Section 135 ng ating rules. Pero dahil inamend ko na nga po, kung pwede na po yung motion to archive, which is consistent to the immediate execution of the decision of the Supreme Court at the rest to this august chamber. Bakit naman po ipinipilit pa nating i-delay based on speculation? Based on the fortunes of whatever the Supreme Court will decide later on, which is based on impossibility.
Noted and entered into the records.
Mr. President.
What is the pleasure of the Honorable Cayetano?
Just 1 minute, Mr. President. Just for the information of the body, there's actually a Supreme Court case about the power to dismiss a case. Ito po yung Velasquez Jr. versus Lisondra Land 2020 case. Ang sabi niya, in order for the court or an adjudicative body to have authority to dispose of the case on the merits, it must acquire jurisdiction over the subject matter. It is axiomatic that the jurisdiction over subject matter is conferred by law and not by the consent or acquiescence of any or all of the parties or by erroneous belief of the court that it exists. Thus, when a court or tribunal has no jurisdiction over the subject matter, the only power it has is to dismiss the action. So Supreme Court na mismo nagsasabi na pag walang jurisdiction, it does not exist. So sabi ng Supreme Court dito, void ab initio yung articles of impeachment. Pag tinitingnan natin rules natin, the impeachment court is triggered by an articles of impeachment. Kung walang article of impeachment, walang court So yes, it's true na it is a fact, not an operative fact. It is a fact na nag-robe tayo, nandito tayo. It is not an operative fact na meron tayong jurisdiction doon. Lastly, Mr. President, sa Rule 39, Section 4, judgment not stayed by appeal. Judgments in actions for injunction, receivership, accounting, support, and such other judgments that are now or hereafter be declared to be immediately executory shall be enforceable after their rendition and shall not be stayed by an appeal. Some may say this is for injunction, receivership, etc., and not for the impeachment court. Ang point ko lang, Mr. President,
Your Honor,
meron naman
this is a case for injunction.
Yes.
Filed by the Vice President against both the Senate and the House.
Thank you for that clarification. But even if it was not, Mr. President, that is why if the gentleman from Tarlac already said he's amendable. So kung halimbawa something like we move to act upon the Supreme Court decision and archive the case. Kasi yung Supreme Court decision, when you act upon, ano ba sabi niya? Immediately executory, ano ba sabi niya? Void ab initio. Ngayon, kung halimbawa, na-reconsider at biglang sinabing tuloy, wala rin naman na epekto yon sa motion na we act upon the Supreme Court. Then, at the proper time, someone can say here, we will act upon the latest decision of the Supreme Court. Diba? So, I'm just saying this in the spirit, Mr. President, na pag nakaboto tayo, at least klaro kung anong pinagbobotohan, because some of us might not vote for the motion to dismiss just because we believe there is no such thing as a motion to dismiss. But I don't think that's our point. Our point is lagyan ng katahimikan to for a few months. February 6, game na ulit.
Noted and entered into the records. Majority Floor Leader.
Thank you.